Good evening. Welcome to the February 16th, 2016 meeting of Lakewood City Council. Please join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please join me in a moment of silence. Madam Clerk, please call the roll.
Anderson.
Present.
Bullock.
Here.
Litton.
Here.
Marks. Here. Nowlin.
Here.
O'Leary.
Here.
O'Malley.
Move to excuse the absence of Councilmember O'Malley on account of illness. Second. Motion's been made and seconded. Any discussion? Hearing none. All those in favor say aye. Aye. All those opposed? And that motion passes.
Reading and disposal of the minutes of the regular meeting of council held February 1, 2016.
Move to approve without necessity of a reading.
Second.
Motion's been made and seconded. Any discussion on that motion? All those in favor say aye.
Aye.
All those opposed? That motion passes.
Item 1, Committee of the Whole report regarding February 16, 2016 committee meeting.
Thank you. Committee of the Whole did meet this evening immediately before this meeting, and we discussed a number of items, including several open appointments for council for actually various but different reasons. The Committee of the Whole is deferring those appointments. However, we are underway with consideration of several applicants for those positions. With respect to proposed ordinance 2-16, we had an update from Mr. Russell, who indicated that although Planning Commission has responded favorably to the sign code update, we will await a formal transmittal of their recommendation for a later date. We also heard from Mr. Russell with respect to proposed resolution 8849-16, which is leasing space in the Community Health Center, 1450 Bell Avenue. The Committee of the Whole did recommend that proposed resolution for adoption this evening. We also discussed proposed ordinance 17-16 and placing that on second reading this evening. Move that report be received and filed.
Second.
A motion's been made and seconded. Any discussion of that motion? Hearing none. All those in favor say aye. Aye. All those opposed? That motion passes.
Item 2, Resolution 884016, a resolution appointing blank to position of the Civil Service Commission.
Move to defer.
Second.
Any discussion on that motion? Hearing none. All those in favor say aye.
Aye.
All those opposed? And that motion passes.
Item 3, Resolution 884116, a resolution appointing blank to the Board of Nuisance Abatement Appeals.
Move to defer.
Second.
Motion's been made and seconded. Any discussion on that motion? Hearing none. All those in favor say aye.
Aye.
All those opposed? That motion passes.
Item 4, Resolution 884916, a resolution to take effect immediately provided it receives the affirmative vote of at least 5 members of council, or otherwise to take effect and be enforced after the earliest period allowed by law, authorizing the mayor to enter into a lease agreement with Lakewood Hospital Association for the lease of real property located at 1450 Bell Avenue, Suite 220, also known as the Community Health Center.
Thank you. We do have one individual signed up to speak regarding that particular docket item this evening. That is Gerald Phillips. We will hear from him now.
My name is, is it on?
Yes, sir.
My name is Gerald Phillips. I just have a very brief comment on that proposal. I believe that the city of Lakewood has not followed the required procedures for the approval of a lease, and therefore I think it should be deferred and the city follow the right procedures. Thank you.
Thank you. And as a reminder, please do state your address when you address council. That is the last public comment on that particular agenda item. I would move to adopt.
Second.
Motion's been made and seconded. Is there any discussion on that motion? Hearing none. All those in favor say aye. Aye. All those opposed? And that motion passes.
Item 5, Ordinance 1716, an ordinance repealing Ordinance 4915, adopted on and effective as of December 21st, 2015, in its entirety.
Thank you. We do have several individuals signed up to speak on this particular issue, the first of which, again, is Mr. Gerald Phillips. Mr. Phillips.
My name is Gerald Phillips. I live in Avon Lake, Ohio, former resident of Lakewood, also a former member of the Hospital Expansion Committee back in 1976 and 77. I'm talking about Ordinance 1716 and the underlying Ordinance 4915. As I indicated last Thursday, your meeting on the 11th, there's a legal chess game going on between the city and the clinic, and the taxpayers and the residents. The last Thursday meeting was really a smoke screen and a dog and pony show. I mean, the city and the clinic has decided a game plan in order to make sure the hospital deal goes through, which is to delay. And to coin a phrase from one of the political candidates when asked about the appointment for the Scalia appointment, Donald Trump said, delay, delay, delay. And that's what this council is doing. I'd like to talk about Article 25, Section 6, and some comments that was made at the last meeting. If you read that ordinance, there's a provision that says that the primary, regular, municipal, or general election is to be held not more than 6 months or less than 30 days after the refusal of council to reconsider the ordinance or resolution. Such ordinance or resolution shall then be submitted to a vote of the electors. That's the reason why council wanted to delay it. Didn't want to take a vote last Thursday because you were within that window and you didn't want that window. The next sentence talks about the fact that if if there is no such election within that time frame, then it says if no such election is to be held within the time aforesaid, council may provide for submitting such ordinance or resolution to electors at a special meeting. So you may put it on a special meeting because you don't have a regular election within 6 months. Then the last provision says, if no other provision is made at the time of submitting such ordinance or resolution to a vote of the electors, it shall be submitted at the next primary, regular, municipal, or general election. So it gives you all the flexibility you want by delaying it to pick what's the best election for the city and the clinic so that you make sure that the voters don't undo what you've done. And even at the committee of the whole meeting, you talk about passing at March 7th. So if you pass it on March 7th, you'll have a special election because you can't delay it to be within 6 months of the general. Also, at the last meeting, Mr. Butler says that he didn't have an ordinance to submit it, but if you read that first sentence that I indicated, it says, after the refusal of council to reconsider, it says such ordinance or resolution shall be submitted. So it's a mandatory duty to submit it. You should have had also an ordinance to submit it. Obviously, you didn't want that because then that gives the council an excuse, as indicated by the law director Butler, to say, well, we don't have the legislation, we can't do it. That's just a smokescreen to perpetuate your delay. Also at the last meeting, Mr. Butler indicated that you had until Friday, 4:00 p.m. to act in order to get on the ballot. That's totally incorrect. Today is the last day to vote, to register to vote, 30 days before the election. The 30 days fell on Sunday, therefore it's not the previous Monday, it's today. So you have until 4:00 today to pass an ordinance and get it down to the Board of Elections, contrary to what Mr. Butler indicated. Next thing I want to comment about is the Board of Elections letter that you put into the record. There's many occasions where they have expedited election cases where the court orders to put an election within the last 30 days before election. And it's happened very, very, very often. That letter is just to document again to show that, well, we have these problems, therefore we have a legitimate reason to delay. You know, it's a smokescreen. I'm sure somebody from the city, the mayor, or somebody from council called their friend down at the Board of Elections and said, I needed that type of letter to justify your actions. The February 5th, 16th date that's alluded to in that letter has to do with the ballot submission language. You can't submit two separate ballots. You don't need two separate poll books. You know, only a few absentee ballots have gone out. You know, people are still getting the thing, so it wouldn't have caused a delay.
Mr. Phillips, I'm sorry, we're up against time, so we'll have to leave it there for your remarks later on. The next person signed up to speak on this particular agenda item is Mr. Dean Dilzell. Yes.
Thanks, Mr. Chair. I just wanted to briefly state for the record, I do not agree with the allegations made by the previous speaker. I appreciate the points he's making, understand his perspective, but a number of very accusatory allegations are made about council's process, about council's intent. I don't agree with any of those. In addition, I would point out that none of us have crystal balls. We can't see into each other's minds and hearts. So I can't dispute if a speaker says, I don't agree with this, I support that. But if any of us say, such and such is happening because you believe this, or you think that, or your real intention or motivation is this, that, or the other thing, truth is, we don't know what one another are thinking. Truth is, I don't know what my colleagues are thinking because we don't get to deliberate upon this until we're in a public session. And so you're hearing about it at the same time as I am. So I would invite...
Excuse me, we really don't boo as members of a civic discussion. So that won't be accepted going forward. Thanks.
I would simply invite us to give each other a little bit more benefit of the doubt, courtesy, and simply state what you're for and against, and we certainly are obligated to respect that. Thank you.
Thanks. Mr. Dilzell.
Thanks. My name is Dean Dilzell. I live at 1276 French Avenue. Just want to make 3 quick points. I want to say that discussions and decisions have been hidden from the start. You've done everything you could to block citizen input or make unreasonable requests. And this group, as well as other members of the administration, seem to talk out of both sides of their mouth, and I'd like to just flush out some of those ideas. From the start, Mayor led the Step 2 Commission, a small body who made decisions behind closed doors about how healthcare delivery was going to be done in our city going forward, even though this government says we got out of healthcare. Then we went to executive sessions, a process by which we had no idea what was going on, which led to innuendo and hearsay. From our part, we didn't know what was going on. Please share the vision. Don't sell the false narrative of transformative healthcare delivery. So let's actually work in healthcare delivery and understand what's going on. That's the discussions and decisions. You block citizen input or made unreasonable requests. These are presentations we're doing here today. These are not deliberations. You present, we present, and then you get the last say. That's not deliberation. Approximately 3,000 registered voters who stated desire to vote on the closing of the hospital have been denied their ability for this to move forward on your delaying tactics. I want to point out that I did take a look. I was unable to stay here last special meeting. I have a son who's special needs and had to leave. So I didn't get to hear Mr. Butler's comments, but I did get the chance to read some of the summary. I found out in a couple of quick lines that in that case, the commissioners diligently and openly passed all necessary legislation to carry their plan to completion. I don't think that's been the case here. In the second paragraph, had this initiative been brought at an earlier time before there was an executed contract, blah, blah, blah. We brought this as quickly as possible the first time there was legislation. So there was no earlier time to bring forth the issue. And as far as talking out of both sides of your mouth, it's been issued. Nobody wanted to run a hospital. Nobody wanted to present an ability to run the inpatient care. And yet, written into the definitive agreement was specific language that prevented another healthcare system to provide services in what was our hospital. CCF talks out of both sides of their mouths. They talk about leading the way in population health, but when the hospital closed, they gave a 10% bonus to the surgical staff who stayed on and finished it out, while providing a memory tile and a mug for the other members of the hospital staff who stayed. You know where their focus is. So discussions, decisions hidden from the start, you blocked citizen input or made unreasonable requests such as bring us your plan to run the hospital in a week. There are so many details that we have no access to, nor do any potential suitors have access to. That is a totally unreasonable expectation. But it does make for great political grandstanding. And you talk out of both sides of your mouth. You opposed issue 64 on grounds. It removed some of council's powers and encouraged us to go get a referendum. We did. We blocked that. That's all I have to say.
Thank you. I would like to note that there continues to be an assertion that some of council's deliberations were unlawfully secretive. And I'd just like to say that we don't have to wonder or speculate or agree to disagree about that issue, because as we all know, in our society, we've decided that legal questions, the arbiter of those legal questions is the judiciary. And in this particular instance, there was actually a case brought alleging that council's deliberations on this topic were unlawfully secretive. And the court not only denied the temporary restraining order that was being sought, but then went on to deny the preliminary injunction and the permanent injunction, and did so based on factual findings that those deliberations were not unlawful. And so while I, again, as Councilman Bullock appropriately mentioned, respect, of course, the ability of individuals, as they have for many, many months, to continue to voice to council their questions and concerns about this issue, we also, I think, need to come to some common understanding as to some of the terms that we are using, and understand that some of these issues have been decided by the bodies that we've all consented to decide them for us. So with that being said,
Mr. O'Leary, can I make one additional point?
I'm sorry, but we have to, there are
I'd
a
like
great
to go
many
through
people.
what I just said. And look
I'm
and
sorry,
see
but there are a great
if
many
there was
people
any
signed up.
mention
I'm
of
sorry, I'm
unlawful.
sorry, sir, but we have to move on.
Review the tape.
I'm sorry, we have to move on to Bonnie Sykes.
Bonnie Sykes, 1673 Arthur. During the public response part of the meeting last Thursday, Mr. O'Leary asked my colleague, Mr. Coons, to curtail his speech when it was well under 5 minutes. So Mr. Coons sat down and did not finish, he didn't get to finish his remarks. And the reaction of the chair to Mr. Coons was it indicated the city's response to anyone who was not on board with the grand plan. Over the past 12 months, it became quite apparent that the chair of the previous city council was more interested in the length of the speeches instead of the content. And the tradition continues tonight. So let's revisit Mr. Coons' speech since it was cut short. Don't worry, I won't read the whole thing. I'll just touch on just the major idea. Mr. Coons cited a recent example in Northfield, Ohio, where the Cleveland Clinic owned an emergency room, but decided to close it in December 2015, giving the community less than 1 month's notice. The community asked for an extra month to allow time for the district to staff it properly. No dice, said the Cleveland Clinic. They had a timeline, and that was set in stone. Doesn't this sound a little familiar? The site of the aforementioned emergency room would be, quote, repurposed as an express care facility where people will be treated for non-critical conditions, unquote. In Lakewood, The Cleveland Clinic will now own the new emergency room. If it benefits the Cleveland Clinic, the promised emergency room will morph into an express care facility that will treat non-critical conditions at exorbitant prices. Is this the best you can do for your constituents? An express care that will treat non-emergency conditions? We've been down this road before with the Cleveland Clinic. They broke the contract to run the hospital. They did not follow through on the centers of excellence. They orchestrated the losses. I see no reason why we partner with them. I urge you to reconsider the master plan. You've been given a rare second chance to correct a wrong. Repeal Ordinance 4015 and start over now before we are too far into the contract. And I know at the committee of the whole, there was a discussion about Law Director Butler's fear of the breach of contract if the Ordinance 4015 is repealed. Well, thank you. But he was not overly concerned when the Cleveland Clinic breached the lease contract. So I have confidence that this potential breach can be overcome. Thank you.
Brian Essie.
Mr. Chair?
Yes, Councilman.
Just to briefly respond to a couple points. First, I want to acknowledge that I think the petitioners did indeed, as was stated previously, bring their petitions as soon as was feasibly possible. So I want to acknowledge that. Secondly, the process council's following for the proposed repeal ordinance is identical to the one followed last November, December for the proposed implementation of the current master agreement, which is 3 readings, and the only deviation from normal process was one special meeting at which to give one of those 3 readings, which is identical to the process that's being followed here today. In addition, another speaker spoke about there's been a theme objecting to executive sessions. As the council president has stated accurately, the purposes for which the executive session were used last year were legal and appropriate, and in fact resulted in an improvement to the initial offer. So we know that they were effective. And the purposes for that and the results of those executive session discussions were stated publicly before and after. The function of the executive session was simply for a negotiation strategy with the other party to not tip the hand so those negotiations could be effective. So the process was appropriate, legal, and effective. Thank you. Actually, there's one more thing. Once again, there was a misstated fact. The emergency room is an emergency room and not an urgent care center that can only treat non-emergency conditions. That's false. The police chief, the fire chief just corrected that last meeting, and we can review the facts again. Thanks.
Thank you, Councilman Bullock. Mr. Essie.
Yes, Brian Essie, 15306 Edgewater Drive. Thank you. Last week was the first time I spoke in this place on behalf of someone other than myself. I was asked to do that on very short notice, and I accepted it, and I accepted the parameters that had been agreed to on that short notice. Today I speak for myself. The exception of me speaking for other people is I really do believe that I speak and give a voice here for people that don't have the voice and don't regularly attend these meetings, and they've been generally referred to me as the underserved. Now, I think we need to move along here, move forward. I wasn't pleased with last week, and I understand some of you might not have been as well. But life is about choices. There's a choice to go into executive session. There's not a requirement. Yes, there is a court ruling, but it's on appeal. So it's not a final court ruling, at least in my opinion. There's another lawsuit pending. There are choices that were made about that as to whether to participate in that or not. And while we get into these discussions, and I guess we still will about people's motives, I made a comment last week, and you know, Mr. Anderson took offense to that, and that's appropriate for him to do so. I never did use the word illegal. We can quibble over the word of legality, and I explained that comment. I don't think it was really walking back anything, because I still do believe that there is an unlawful law in place. And again, I didn't want to get into the legal arguments and the back and forth, and I don't really want to do that today. Except to say that for those of you that are relying on legal advice of the law director of Thompson-Hine to enter into something, and it is procedurally right, I don't think it's fair, especially for those of you who aren't lawyers, to be suggesting that you personally have done something illegal. You know, if we were to use the word lawful, legal, whatever. Mr. Butler, after I left last week, I watched the video. He made a comment here, and I think I got it accurate, but he said, there's no question but the city council and the city relied on the expertise of citizens on the LHA, and I think the words were, those who had spent so many years in the rooms. Our Attorney General has rules about avoiding stagnation on hospital boards and charitable boards. And it's really become an insider's club, and I commented on this. This is rehashing things, but I want to give an example. If we had a fleet of fire trucks in our city that was maintained by a contractor in our city, and that contract was coming up due, and we put it out to bid, and that existing contractor bid on the contract, and also 2 other contractors did. And the city turned to the existing contractor and asked for help on commenting on another 2 bids competing with it. I think we'd all say that was improper. And Mr. Butler went on to say that something about my reference, and I think Mr. Dilzell's reference last week about the whatever the bidding process was we're referring to. And he said the bidding process of LHA that you relied on resembled that. May I suggest that having the Cleveland Clinic trustees part of the select committee that selected Subsidian, the Cleveland Clinic trustees part of the Step 2 committee that evaluated and reviewed bids by the other bidders and interest by the other bidders would not be tolerated in any normal or proper evaluation of bids. So, I could go on, but I think we need to restore trust in this place. This is not a courtroom to be debating legal principles, but we get into that, and I've tried to avoid that recently because I don't think it's productive. I think you should vote to put this on the ballot and have a special election. I think delaying it just is going to create less and less trust. But trust is not something that just happens. It's created. It's about a future behavior, and it requires a track record.
Sorry, Mr. Essie, we are up against time here.
Thank you.
Thank you. That brings us to Tom Monahan.
Good evening, my name is Tom Monahan, I live at 1487 Waterbury Road. And last week was one of 5 people invited to take part in what can be best described as a sham spectacle. I chose not to. It was a disingenuous act on your part to give such late notice when you folks have been planning this move for some time. I'll bet you $1 a donut that you gave our part-time law director more than 6 hours to craft his insulting opinion about the efforts of members of our community who do not agree with you. You should remember that his opinion is only one viewpoint, and there are always other points in law that will be decided by the courts. Your actions last year reveal very clearly your plan to speed up the closing of the hospital in order that you can pin your argument on this opinion. Your bold-faced attempt to smother the opposition with this opinion has had a very dramatic reverse effect. Instead of what you had hoped for, that it would silence us, it has only energized us and many new residents of the city who are coming to realize that the mayor and most of the council members worked so hard at shilling for the clinic that it will eventually cost us dearly. Everywhere I go, people are beginning to talk about you and our city. You now join the mayor as being the only council in the United States, and this consists of 19,000 cities, villages, and townships, that have worked to drive more than 1,200 jobs out of our city. That is something you can put in your political campaign literature. People can't understand why you would reward a healthcare system with such a generous, one-sided master agreement after it had never kept its word on its original '96 agreement. They can't understand who could pick up the $7 million a year in charity care that Lakewood Hospital provided to the underserved. They can't understand where some 10,000 people who used to use our ER are going to get their needed help. It was apparent from the long-time planning of the destruction of the hospital outlined in the Buchanan plan, they never were really considered as human beings in need of ER services. But I'll bet you when the mayor sold his family business, he drove a hard bargain and got top dollar for that business. I'll bet you he didn't sell his company for pennies on the dollar, as he did with our hospital, and I'll bet he didn't throw in another $30 million in equipment free just to please the new buyers. Mayor, show us your plan you have for the hospital site. Let's stop this secretive way of yours and show the public how we will be better off with it. The resultant master agreement is one of the most one-sided and despicable legal documents I have ever seen. It reeks. The mayor and his team shilled for years, spent hundreds of thousands of dollars on so-called experts and legal teams and came away with a document that sanctifies the monopolization of the clinic. The clinic has used myths and mirrors for years to try to keep its stranglehold on Lakewood. I remember in '96 in this very room they first stood at this and made all kinds of promises that they would be a good partner for Lakewood. In 2010, I listened to their pitch about placing centers of excellence in the hospital to make sure that our hospital will be strong and viable for years to come. All the while, plans are underway to decant our hospital under the leadership of the mayor and a select group of clinic appointees. Another myth the clinic continues to fabricate is that it has a downtown campus. Can't find it, you never will find it, because it's out at 9500 Euclid Avenue. And still another myth foisted on us last year is if we allow the clinic to carry out its plan, Lakewood would become the healthiest city in America. In fact, people would come to Lakewood from all over the world, all over America, and see how healthy we are. If they want to talk to me and see how healthy I am, I'm surely going to charge them a hefty facility fee. In ending tonight, I want to assure you that you have not seen or heard the last of us. We pledge to be here every council meeting to remind you of how you lack the political backbone to stand up to the mayor and the clinic. It is evident among you that there's even a member who believes that thousands of pages of subpoenaed pages of documents and deposition transcripts are only opinions, not fact. He also admitted last year that we may never recover from all the lost income because of that plan. The clinic wanted out of its '96 agreement, and you should have seized that opportunity and set stringent terms that favor our city and kept more than 1,000 jobs and all the benefits. The clinic was never going to leave here and give up this lucrative area, and that proof positive is in the master agreement. Had you an ounce of political guts, you would have taken the situation, told the clinic that if it wanted to get out, that you had terms it had to meet. You should have scrapped any form of the master agreement and done your own due diligence in searching out a partner for the hospital. The clinic has shown you how to negotiate from its strength. It's a shame that you did not recognize that you held all of the aces. Thank you.
Thank you. Ann Gill.
Hi, my name is Ann Gill. I live at 1255 Jackson Avenue. I've been a resident of Lakewood and a registered nurse for 36 years. I'll speak briefly that my major concern is the lack of serious pursuit of other options for Lakewood Hospital. I don't really see any innovative thinking. I don't really see any serious invitation to other people in the country that could run it. I lived up in Alaska for 2 years. Their problems and their situations and their solutions are very different. They would think nothing if they needed a supervisor in a hospital to pull one from another state. They did this on a routine basis. They were used to solving problems with solutions that we would be very unfamiliar with. I am concerned about the emergency room. I don't feel just because everyone says it's an emergency room, it lacks the services. I was in an emergency room for 17 years. I don't believe you can get the level of care you could have here, that you could have gotten 10 years ago. I don't, as a resident, that concerns me, and it makes me feel like I want to move somewhere else. That was I think, a wonderful thing about Lakewood, was the level of care you could get at their hospital. But that, due to the agreement they made in '96, that was a wonderful idea to come in here. How many times does Cleveland Clinic have to lie, or tell a story, or change their mind about something? Over and over again, they've taken resources out of here. The president of the California Nurses Association, her name slips my mind, would call the process medical strip mining. They've renewed resources over and over again. You continue to make agreements with them. I would ask if there was any serious concern for other options, that you take out a one-page ad in the New York Times. I think you would get more answers to that and more solutions. The problem is nobody wants to think outside the box around here. Thank you very much.
Thank you. Some points were raised with respect to the level of emergency services to be provided. Because that implicates a very important public safety issue, I would ask Chief Gilman if you'd be so kind as to respond with respect to the services that are provided in the new emergency department. Thank you.
There's truth to some of the things you say. In Cuyahoga County, we have the Northern Ohio Trauma System. Over the past 6 years, the consolidated trauma centers gone from 5 to 3. They're the only county in the state of Ohio to see a reduction in trauma mortality. So when you take services out, you've improved services by consolidating them into facilities that see and deal with it all the time. From my perspective, it will be interesting to see how that changes with the addition of another level 1 trauma center on the east side of Cleveland. A lot of the people on the committee did not feel that that level 1 trauma center was necessary. There are changes to how we will transport patients, and our goal is to make sure that patients get proper assessment, that we get them to the facility where if they need an inpatient bed, they can get an inpatient bed. If they don't need inpatient beds, they'll still be able to be treated at the freestanding emergency room. Other cities, Brunswick and Twinsburg, have utilized, they each have 2 freestanding emergency rooms, and I've got a breakdown on their statistics. They transport close to 70% of their patients to those emergency rooms. They will use them differently than we do. Within 10 miles of Lakewood, we have 5 different hospitals within 10 miles. They don't have a single hospital within 10 miles of them. They have to use those freestanding emergency rooms to help stabilize patients that can't be stabilized in an ambulance. We have the luxury of having 10 hospitals within 10.5 miles of the city. It's much different than it is in Summit County or in Medina County. So, yes, there are less services there, but that goes with the change in healthcare and how trauma services have been consolidated. Other services, we've seen an improvement in time. The time for cardiac caths to be completed was reduced when before they were using the shared team. Now they've went to 1 team. They're waiting for us when we arrive at the ER at Fairview. The patient goes right to the cath lab. The time it takes to get the cath completed is less today than it was last year. So there are services that have changed, but I've seen improvement in some of the services provided.
Thanks. Our next speaker is Kevin Young.
Good evening, everybody. I'm Kevin Young. I live at 1598 Elber Avenue. You know that I deal with rock bands all the time, and I manage bands, and whenever I go into an agreement, I call my lawyer and we work something out. And when everything's worked out, my lawyer always reminds me that, Kev, we got it in paper, but when it gets right down to it, it's always a matter of trust. And I think that's true about everything when it comes to what's legal and what's not. You know, it's always a matter of the way people feel. And if people are not feeling good about what you're doing and you've got a legal agreement, that can make things rough. You might win when it's all said and done with, but the process is very, very damaging. You guys are losing trust in the community. You know, and I like a lot of you here. You know, I've had great conversations with you. I think you all have good intentions, but you've got to know that you're losing a lot of trust. And whatever the legal angles, one way or the other, might be, in, you know, whether you can get something to the Board of Elections in time for a March election or not, or whether you decide to have a meeting that might be legal on paper in private, that starts to build up, and that starts to make people doubt what you're all about. You've got to make yourselves aware of that. And you're bringing yourselves closer and closer to an all-out, I don't want to say war, but an all-out rebellion among the citizens of this community. And it's not happening just because some rebels are stirring things up. It's happening because people are getting that feeling. So, I wanted to share that thought with you tonight. You know, I just got this interesting email from Marguerite Harkness, and she was talking about the billing at for a procedure that she had at 850 Columbia Road, our facility out there west of here. It was a short procedure. She doesn't say what it was, but the clinic charged $12,000 for use of 1 hour of this operating room where this procedure took place. And she started to break it down. $12,000 an hour for 8 hours a day equals $96,000 a day for rent for this one room. That's before any of the doctors get their bill, you know, that's before anything is billed for the doctors, anesthetics, or whatever like that. All right, and then she goes on, $96,000 a day, 5 days a week equals $480,000 of rent a week for this one room. 52 weeks in a year, and it comes to about $25 million a year for just that one room. There's a lot of money at stake here. We're throwing away what seems to be a cash cow, all in the name of this idea that healthcare is changing. I think this whole notion of healthcare is changing is just a smokescreen so that people can grab money. And that gets back to the trust thing that I was talking about. Everybody knows that this is about the money. Please beware of that. This is time for bold action. And you've got to take control of this situation that is running away. Thank you.
Thank you. Councilwoman Marks.
Thank you, Mr. President. Kevin, I appreciate you sharing what Marguerite Harkness shared with you, but I can tell you that what she needs to share is not just what is billed, but what got paid on that service line. I work in healthcare. We get about 28 cents on a dollar. Now you tell me how long you could be in business getting 28 cents on a dollar. So I would like Ms. Harkness to actually add to that, perhaps for the next meeting, and let us know what they were actually paid by the insurance company for those services. Because I think those are the kind of perceptions that mislead people to think otherwise. So please be clear when you're explaining things to the public that it's not just what gets billed, but what is actually paid. I'd appreciate that, perhaps for the next meeting. Thank you. Thank you.
Thanks.
Mr. Chair.
Mr. Bullock.
Just briefly, there's a lot said tonight, and I can't respond to it all, but I just want to drive the key point. There's a widespread misconception that LHA, the Lakewood Hospital Association's costs, their operational maintenance and other obligations associated with the 1996 lease were passed through to the clinic in the definitive agreement, the former one. That is not an accurate perception. That's not reality. And that's a key point because That means,
Enforced.
I want to do air quotes, but I have to hold down the button. Enforcing the contract won't result in the hoped-for outcome expressed by many of the citizens tonight. What council has to do is pursue results that are effective and attainable. And under the circumstances, that's what we did. In fact, we did what was best under the circumstances, and maybe a little better than that. So I would try some of the very tactics and methods expressed if I thought they would lead anywhere and be effective, if they would deliver the goods for the residents of Lakewood. But they won't. They never did have a chance. And that's why I never advocated for those things. What's been missing from the analysis presented is any appreciation of the business case. Unless and until our medical system in America is like that in Canada or the United Kingdom, in other words, a government-run single payer, and there are people who advocate for those, pursuing a government-only contractual basis for health systems isn't going to achieve as much as people are hoping. And that's why we get into private sector three-way contracts. In fact, this all, as Mr. Graham probably recalls, harkens back to the 1985-86 debate when there was a charter amendment originally divesting the city from direct ownership of the city, of the hospital, and it set up the Lakewood Hospital Association. So that this is actually a very important fact to the whole thing. And so what success looks like is not pounding the table and getting angry with the clinic. What success looks like is effective negotiation. That is what council achieved in the past year. Thank you.
Thank you. Up next, we have Pam Watula.
I'm Pam Watula, 11813 Clifton Boulevard. Thank you for having me. When I first heard about the LOI, I really didn't believe that Lakewood would allow CCF to break a lease without repercussions and substitute a medical office building for a hospital. I didn't believe it. Especially after years of work to upgrade or maintain city services. For instance, the library, the parks, the schools. As an inner ring suburb, we were holding our own against urban sprawl and inner ring decay. I sincerely believed that the city would actually listen to the citizens when they spoke. I thought there isn't a mayor in the world who wouldn't fight for Lakewood Hospital if it was in their own community. That elected officials would always fight on the side of more services, more employment, not less. I trusted that. When the decanting plan was revealed through deposition, I just knew that our officials would see through the sham and realize that Cleveland Clinic Foundation was not their friend, that they would go forth with a competitive bidding process to bring comprehensive services here and to maintain that. Instead, there wasn't a whimper about curbing urban sprawl. Instead, Lakewood leaders used our diverse demographics to support CCF's agenda. Instead, no one is listening to the citizens, or the city council members expressed that they were insulted to be questioned by citizens. Or the city council was telling us that it was their job to save Lakewood Hospital, not ours. Or city council was telling us healthcare in Lakewood is not their job to provide for us. Instead, city elected and appointed officials have chosen to ignore the obvious destruction of Lakewood Hospital. Instead, Lakewood has refused to acknowledge the impact of the decanting plan. Instead, Lakewood has entered into a master agreement that, number one, gives away our assets for pennies on the dollar. Number two, includes meaningless items like access to the one mobile stroke unit in the whole area, and the availability and the City of Avon's proposed revenue sharing with us, which we know is a sham. It also includes a restrictive covenant that acts as a non-compete for the Cleveland Clinic Foundation's benefit, not Lakewood's. When the citizens produced enough signatures for a referendum petition to place Ordinance 49-15 on the ballot, I have to say that I believed, I trusted, the vote of the people would be heard in a timely fashion. Instead, the City Council and Law Director Butler delayed the process. The Cleveland Clinic and LHA rushed to gut Lakewood Hospital. They put forth an ordinance for the repeal of 49-15 when it had no intention, City Council had no intention of repealing it. They played games with the petition committee, of which I am a part, by giving us 6 hours by email notice to put together a comprehensive 30-minute presentation to you. Additionally, City Council wanted an instant plan after telling us that it was none of our business for 1 year. They wanted an instant plan to take care of this situation when the citizens repealed 49-15. And the pièce de résistance? Mr. Butler came up with a case that he says will allow the vote of 5 or more City Council members to negate the vote of 7,000 to 10,000 citizens who intend to vote against Ordinance 49-15. That's right. Now the city does not intend to honor our vote. After all, everyone knows that all case verdicts are valid, right? Everyone knows that verdicts cannot be questioned, and they're never changed. And everyone knows that there is no chance that a case exists that might have a verdict that proves the opposite of Mr. Butler's case, does not allow the city to stomp on the will of the people. Middleton versus Ferguson in 1986 was about road work, not health care. It is not about the city bending over for a big corporate entity. Cleveland Clinic Foundation already owns Cleveland. Why should Cleveland Clinic Foundation own Lakewood?
I'm afraid we'll have to
Every
leave
city
it there for
official who
tonight.
votes or
I'm
makes
sorry.
as if their
Our
vote is
next
more
speaker,
important than the
I'm
citizens.
I'm
Thank
sorry,
you.
thank you. Our next speaker for this evening is Judy Gillespie.
I'd like to tell you that I had signed up on both of the sheets over there, one for public and one for the agenda. So I don't know how you want me to handle that, if you want me to handle that all at one time. One is just.
We're speaking on a docket item.
Okay.
We're on docket item number 5. I know it's difficult for folks to remember. We're still on docket item number 5. And at the end of the meeting, we'll have public comment, as we always do, and have for the past year on this issue. Thanks.
Okay, thank you. Judy Gillespie, 23003 Chandler's Lane, Olmsted Falls. I've given you the definition, the noun definition for the word trust a couple weeks ago. Now I'm focused on accountability, and I'm more than happy to give you my source, which I found online, is at vocabulary.com, dictionary /accountability, and it says, accountability is a noun that describes accepting responsibility, and it can be personal or public. A government has accountability for decisions and laws affecting the citizens. An individual has accountability for acts and behaviors. Sometimes, though, taking accountability means admitting that you've made a mistake. I find that interesting that the dictionary would state that. Words that have been used just this past week to describe you as a city council are what I have found as obstructionist council, unaccountable for delays concerning the BOE referendum process. That's okay that you can do that. Manipulated discussions when you set the committee up with a notice at 11:38 in the morning, and God forbid somebody doesn't check their email until 2 o'clock in the afternoon, then they're even have a shorter time frame. So there was no respect in that announcement that we could have a committee present our comments. Manipulated decisions, out of balance elected official behavior. Now I thought that was a real good jacket that each one of you can wear, including the folks on this side of the room too. I find trying to restrict a podium speaker his First Amendment rights when he was told he had to direct his comments to the president. Mary Louise jumped out of the walls on that one, didn't she? And somehow I look at that as a very silly rule that whoever's here at the podium can only speak to the president, when in fact there are times when we need to speak and look at our mayor who sold us out. And I keep saying our, and I'm so sorry. I've lived here 46 years and I keep forgetting that I've been gone a year. I apologize for that. Your responsibility is to represent the city of Lakewood residents, who, by the way, are the ones who are paying your salaries, not representing the Cleveland Clinic. You are supposed to be the dog that wags the tail, but instead you present yourselves as the tail being wagged by the dog. In case you have forgotten, the original 30-year management contract that was written between the Lakewood Hospital Association and the Cleveland Clinic with the city of Lakewood, represented by the mayor that I'm not allowed to look at, and the two individual council members, one still remaining, not 7 total council members. I understand clearly why the city was to be represented on the association, the Lakewood Hospital Association level. It was never intended to allow the mayor and the 2 council members to remove their responsibility to the residents of Lakewood, but it was intended to protect and maintain the functionality of that profitable state of operation that was present at the time of the signing of that contract. That hospital was not in trouble. The hospital was serving the community and viable at meeting the needs of the community 18 years ago. The association just didn't want to be the manager anymore, so when the Cleveland Clinic approached them with their offer, by the way, I believe you could more appropriately refer to the Cleveland Clinic as the sheep in wolf's clothing, or the decanter looking for a willing wine to possess. Letter of intent, in my opinion, was nothing more than Cleveland Clinic dictating, not negotiating, the manipulated contract with the blinded and gullible association who was so willingly accepted the concept from the Cleveland Clinic that Avon, a city of 22,000 people, needed a full-service hospital, but Lakewood, a city with 52,000, no longer needed a full-service hospital. LHA was then re-educated by the decanter, aka the wolf, on accepting the new focus for 2015, the year of the wellness approach to healthcare now. Ironically, when the city of Avon was approached by the...
Sorry, Ms. Gillespie, we'll have to save the rest for your comments at the end of the meeting.
Oh.
Ms. Tara Pepper.
Tara Pepper, 1278 Edwards Avenue. So as promised, I will not sit back and quietly accept this. You have not done your job seeking a viable option. You are not representing the people of Lakewood. In the early situation, the early discussions I had with Councilman Anderson, Councilman Bullock, and a little bit with Councilman Marks, never once was it mentioned tortious interference. I realized at the time there was a decanting plan, so that was very clear to me. But the tortious interference, now this justifies why there was no public bid. There was no bidding. So nobody could make a bid or an offer to run our hospital because of tortious interference. So now that the people have given 3,400 signatures, the people have spoken. This is an open door for you to step up as our leaders. It's an open door for you to reach out and put an open public bid out for our hospital because, well, I don't know the legal terms, maybe our law director Butler could explain, but if you've released the clinic from that deal, or release the clinic from managing our hospital, and there is no longer tortious interference, then we are free to put out an open public bid, and I've not seen that, and I will not sit back quietly until we have an open public bid. You're our representatives. This is what you should be doing for us. Issue 64, bad choice, watch Lakewood Hospital close permanently. How can you make such a statement? Force a huge tax increase on the taxpayers? How on earth are you going to replace 1,200 jobs? I told you, I did my taxes. It was over $1 million hole in the economy, replaced with $30,000. This is irresponsible. This is not good leadership. We stand before you. My God, Gerald Phillips spoke. Another amazing person I meet in this community of Safe Lakewood Hospital. Sound legal advice. I'm sorry, Councilman Bullock. Not accusatory. It's blatant truth. No one is misleading. When you speak of misleading the people, there were other advertisements here. Skindella's naive. He backs the emotionally charged group hell-bent on keeping the hospital operating an inpatient model. An inpatient model when Avon's building this grand facility, counting on our tax dollars, counting on our constituents to serve their purposes, their financial gain. This is wrong. So I beg you to put out an open public bid. If you want us to be quiet, put out a genuine open public bid where there's no tortious interference. It's a genuine open bid for another partner to run our hospital. That would be true leadership. We're giving you the open door. We've collected the signatures. The people have spoken, and the more people we speak, the more people who understand this are questioning the leadership in Lakewood everywhere. I had a student in my office today, and sure enough, it was, oh, on the hospital? Sure, I'll send you the link to Gerald Phillips, the presentation from the last meeting. Remarkable. People are like, that's great. So we're going to continue to do this. Now it's your turn. It's your turn. If there's no tortious interference, which I would hope at this stage, then there should be a true open public bid, and we'd be quiet. Please, do your fiduciary duty. Thank you.
Thanks. I would note in response, there were, I think, a number of points raised in our discussions last week. First of all, with respect to tortious interference, I think as a factual matter, it's significant that the city did set about obtaining and was able to obtain from the Cleveland Clinic Foundation a release from tortious interference concerns for the Metro Health discussion that was ongoing at that time. And so those discussions could have taken place uninhibited had there been another interested partner on the other side of the table to have those discussions. Excuse me, I'm sorry, but the other thing that I was going to underscore about the fact that this wasn't let out to public bid previously were the comments that I made last meeting, and I don't know if anyone else remembers, but I remember speaking on this for a little while, and the fact that, first of all, Lakewood isn't under an obligation to bid it in that way, and that second of all, the reason for that is that there are some circumstances where a better deal can be obtained through a non-conventional bid process. And we've seen that employed in a number of different contexts, in a number of different instances throughout the process of acquisition that the city goes through for a number of services and goods. So with that being said, that brings us, I believe, to the end of the docket comments for docket item number 5. Yes. Councilman Bullock.
Just briefly, a couple add-on points. Also, tortious interference stems from the fact that there was a contract in place going back from 1996. And it's a feature of a private sector contract to operate the hospital. So tortious interference isn't something that City Council created or granted or felt happy about necessarily. It just is a feature of the fact that in 1996, I imagine from 87 to 96, there was an agreement under the agreement with university hospitals that the tortious interference would have been a feature there too. I wanted to briefly also, the 5-minute rule in council's rules on public comment. I appreciate the fact that this is important forum for First Amendment expression and for us to hear from citizens. The logic behind this, and this is up to council and the presiding leadership of council also, but there's a couple features to that. One is, out of courtesy to other citizens and to encourage focus so that somebody doesn't potentially take up 45 minutes of time, which can happen, we allow each other opportunity to speak. And you can sign up on multiple issues as people do, and I think are tonight. Secondly, the rules about addressing the chair are common in legislative bodies, and it's encouraged to do, it's to allow for etiquette. If everybody recalls, there was a not so pleasant moment in the U.S. Congress during the Civil War where somebody got caned, and it was in the lead up to the Civil War, and the northern gentleman who was the subject of the beating got a lot of damage that he never fully recovered from. That's an extreme case, but that's the logic behind these formalities. It's the equivalent of not pointing a finger directly at one another. So all of us are encouraged and obligated in a civil courtesy manner to operate accordingly. So that's the reason behind the chair trying to conduct the meeting in a timely and courteous manner. Last thing I want to say is allegations have been made about the mayor not doing a good or forthright job on the hospital. I want to state for the record that's I don't agree with that. I think that's false, and that's based on mistaken understanding of the facts. If you recall, the mayor, in a very direct and forthright manner, in an election year, stated his view on the path that the community and the city and the hospital ought to take. It's very unpolitician-y kind of stance to take. In fact, I challenge you to find any other local elected official who would be so direct and not worry about the election. I think that's important to note. And not only I think the analysis that the mayor provided was affirmed. He had council agree, unanimous decision, and the voters agreed.
Thank you. Moving on, that, as I said, brings us to the end of the public comment for that docket item, which is ordinance number 17-16. As we've heard tonight, there is a wide gamut of community sentiment on this issue. Council members continue to deliberate on that, and I would, as a result, recommend that I would move that we place this on second reading this evening.
Second that motion.
Motion's been made and seconded. Any discussion on that motion? Hearing none, all those in favor say aye. Aye. All those opposed, and that motion passes.
Item 6, Finance Committee report regarding ordinance 3615A.
Councilman Bullock.
Thank you, Mr. Chair. The Finance Committee met tonight and got a briefing from the Finance Director and from the Planning Department regarding proposed additions to our contracting authority ordinance number 3615A. And there were 3 proposed changes which the committee ultimately agreed were good recommendations. And so I'll say at the beginning here that the recommendation of the committee was that we adopt the substitute version of the ordinance which the clerk has with us tonight. And those changes are in 3 locations. Number 1, to add $30,000 for of contracting authority, I should say, for organic waste disposal. Number 2, for biosolids disposal, a $10,000 increase. That's due to inflation in those costs. And on the organic waste issue, it used to be the case that other vendors would come and pay us to take away the leaves and the mulch and those kinds of things. We hope that in future years the market will recover such that they do that again, but for this year we now have to provide for those materials being hauled away from our collection facility down in the valley. Third item is contracting authority of up to $150,000 for professional services related to the hospital transition, specifically managing the properties that have come into the city's possession once again. So far, the estimate for the anticipated cost is not $150,000, but about $100,000. And those would be for property management for the Curtis Block, for the Community Health Center office building, and for the 9 single-family homes located on the 10 residential parcels. There's one vacant that we now own. And the other item is for assessment of the Curtis Block building for structural integrity and any asbestos that may or may not be there as a preliminary step towards developing or rehabbing or putting that building into productive use again. Move to receive and file that oral report.
Second, any discussion on that motion? Hearing none, all those in favor say aye. Aye. All those opposed, and that motion passes.
Item 7, ordinance 3615A, an ordinance amending ordinance 3615 adopted December 21st, 2015, to enter into contracts for professional services and to advertise for bids and enter into contracts for the purchase of repair, maintenance, and operating supplies, services, and equipment as authorized by the 2016 appropriation ordinance.
Move to substitute.
Second.
Motion's been made and seconded. Any discussion on the motion to substitute? Hearing none, Madam Clerk, please call the roll.
Anderson?
Yes.
Bullock?
Yes.
Litton?
Yes.
Marks?
Yes.
Nowlin?
Yes.
O'Leary?
Yes. That motion passes. I move to adopt.
Second.
Motion's been made and seconded. Any discussion on that motion to adopt? Hearing none, all those in favor say, I'm sorry, we have to call the roll on this.
Anderson?
Yes.
Bullock?
Yes.
Litton?
Yes.
Marks?
Yes.
Nowlin?
Yes.
O'Leary?
Yes. That motion passes.
Item 8, Public Works Committee report regarding Resolution 88-5016 and water quality discussion and bikes in bus lanes.
Councilman Nellen.
Thank you, Mr. Chair. Dear colleagues, the Public Works Committee met on Monday, February 8th. All members of the committee were present, as well as Councilmember Marks, Director Benno, and a member of the public. The committee first discussed resolution number 8850-16, which would authorize the mayor to enter into a stormwater service agreement with the Northeast Ohio Regional Sewer District, the NEORSD. The proposed agreement would not cost the city anything, but would potentially cause the city to receive 25% of the stormwater fee collected by the NEORSD, which could mean an additional $2,500 to $3,000 to the city. Lakewood must apply for the funds by proposing a project, and if the city does not use the funds or propose use for the funds within 5 years, the fees revert back to the NEORSD. After further discussion, resolution number 8850-16 was unanimously recommended for adoption by the full council. The committee then discussed Councilwoman Marks' recent communication regarding Lakewood's water quality. Director Benno discussed the current protocol for testing lead in our drinking water, including the testing procedures and schedule. The committee then discussed the prevalence of lead pipes in the city and the importance of the addition of orthophosphate to our water supply, which prevents pipes from leaching lead into the water. The committee discussed the possibility of publishing the results of all water quality testing on the city's website. Director Benno noted that when the city replaces a water main, it will notify the homeowners on the affected street that they may have an opportunity to replace any lead pipes while the project is ongoing. The committee also discussed how it may further consider issues related to water quality and testing. Finally, the committee discussed recent communication from Director Butler regarding a code revision allowing bicyclists in Clifton Boulevard bus lanes. The committee may formally take up the code change upon the introduction of a proposed ordinance. Move to receive and file that report.
Second, any discussion on the motion to receive and file that report? Hearing none, all those in favor say aye. Aye. All those opposed, that motion passes.
Item 9, Resolution 885016, a resolution to enter into a stormwater service agreement with the Northeast Ohio Regional Sewer District.
Move to adopt.
Second.
Motion's been made and seconded. Any discussion on the motion to adopt? Hearing none, all those in favor say aye. Aye. All those opposed, that motion passes. I would move, as we approach item 10 here, to suspend the rules so that the clerk can read items 10 through 19 together.
Second.
Motion's been made and seconded. Any discussion on that motion? I'd add that these ordinances together comprise the city's bonding ordinances, and that's why we're asking that they all be read together. With that, All those in favor say aye.
Aye.
I'm sorry, it's a motion to suspend the rules. We'll need a roll call vote on this. Madam Clerk?
Anderson?
Yes.
Bullock?
Yes.
Litton?
Yes.
Marks? Nowlan?
Yes.
O'Leary.
Yes.
Item 10, ordinance 516, an ordinance authorizing the issuance of not to exceed $18 million of bonds for the purpose of currently refunding notes issued for the purpose of the city's West End sewer separation project. Item 11, ordinance 616, an ordinance authorizing the issuance of not to exceed $26,500,000 of bonds for the purpose of currently refunding the city's Rockport Square Improvement General Obligation bonds. Item 12, ordinance 716, an ordinance authorizing the issuance of notes in the amount of not to exceed $4,845,000 in anticipation of the issuance of bonds to pay costs of designing, engineering, and constructing sewer improvements. Item 13, ordinance 816, an ordinance authorizing the issuance of notes in the amount of not to exceed $1,640,000 in anticipation of the issuance of bonds to pay costs of designing, engineering, and constructing water improvements. Item 14, ordinance 916, an ordinance authorizing the issuance of notes in the amount of not to exceed $1,500,000 in anticipation of the issuance of bonds to pay costs of improving Andrews Avenue, Athens Avenue, Chesterland Avenue, Concord Drive, Delaware Avenue, Erie Cliff Drive, Hall Avenue, Lake Point Drive, Leedale Avenue, Leonard Avenue, Mars Avenue, McKinley Avenue, Northwood Avenue, Richland Avenue, Shaw Avenue, and West 117th Street, and other streets. Item 15, ordinance 1016, an ordinance authorizing the issuance of notes in the amount of not to exceed $750,000 in anticipation of the issuance of bonds to pay the costs of improving parks. Item 16, ordinance 1116, an ordinance authorizing the issuance of notes in the amount of not to exceed $650,000 in anticipation of the issuance of bonds to pay costs of improving sidewalks. Item 17, ordinance 1216, an ordinance authorizing the issuance of notes in the amount of not to exceed $355,000 in anticipation of the issuance of bonds to pay costs of improving Franklin Avenue and Hilliard Road. Item 18, ordinance 1316, an ordinance authorizing the issuance of notes in the amount of not to exceed $200,000 in anticipation of the issuance of bonds to pay the costs of replacing or improving roofs of the fire station and Winterhurst Ice Rink. Item 19, ordinance 1416, an ordinance authorizing the issuance of notes in the amount of not to exceed $704,000 in anticipation of the issuance of bonds to pay costs of providing, constructing, and installing a revetment on the northerly property line of the Meridian condominium. Item 20, ordinance 1516, oops.
I'm sorry. Move to place on second reading.
Second.
Motion's been made and seconded, and we would ask for a roll call vote as we are, the motion is to place all of these items together on second reading.
Anderson?
Yes.
Bullock?
Yes.
Litton?
Yes.
Marks?
Yes.
Nowlan?
Yes.
O'Leary.
Yes, and that motion passes.
Item 20, ordinance 1516, an ordinance amending section 55705, fees of the codified ordinances to reflect that the application fee shall not be refundable as the city's actual cost in accepting and processing any permit application, along with the minimal services required for any special event permit exceeding the application fee.
Move to place on second reading.
Second?
Motion's been made and seconded. All those any discussion on that motion? Hearing none, all those in favor say aye. Aye. All those opposed, that motion passes.
Item 21, ordinance 1616, an ordinance to amend section 114305, schedule of uses and space requirements of codified ordinances. Placed on first reading, refer to the Planning Commission 2116.
Move to place on second reading.
Second.
Motion's been made and seconded. Any discussion on that motion? Hearing none, all those in favor say aye. Aye. That motion passes, and we're on to new business.
Item 22, communication from Councilmember Bullock regarding reintroduction of legislation to implement recommendations from the Lakewood Tree Task Force.
Councilmember Bullock.
Thanks, Mr. President. Dear members of council, trees are good. The Lakewood Tree Task Force, at the conclusion of its formal work several years ago, made recommendations to the city regarding tree planting and maintenance practices that can help us achieve our urban forestry and canopy coverage goals more quickly and effectively. In 2014, I proposed on their behalf 4 pieces of legislation to implement several of their 19 recommendations. 2 of those proposals were adopted by council, 1 was deemed not necessary, and the 4th still awaits council action. Accompanying this letter is my reintroduction of that legislation, the 4th item. A resolution that, or rather to, endorse the principles for tree care and urban forestry management goals recommended by the Tree Task Force. These principles and goals would serve the important function of establishing policy and would provide guidance to our strategic planning for urban forestry. In addition, by this communication, I request a hearing with the administration regarding its 2016 tree lawn planting program and a discussion of whether, how, and under what circumstances this might be extended to those streets that lack sufficiently wide tree lawns by permitting planting of city trees in front yards on the private side of the property line. This possibility has been discussed as a potential means by which the city's inventory of potential planting sites could be expanded and by which additional street trees can be planted to the benefit of stormwater management, health, beautification, and property values. I request a referral of this communication and the attached resolution to the Public Works Committee for further deliberation. Sincerely.
Thank you, Councilman Bullock. I'd just like to begin by thanking and acknowledging Councilmember Bullock for his really continued leadership on this issue, as well as the mayor and the administration for their focus on this issue as well through the creation of the Tree Task Force. I know that for many of us this was an issue that Hurricane Sandy brought into sharper focus, but one that really is abidingly important to many of us. So I really appreciate and respect Councilmember Bullock and his willingness to bring this issue back to our attention. With that, I would move to receive and file that communication.
Mr. President?
Yes, I'm sorry.
May I?
Yes, yeah, absolutely.
I'd like to also agree with you. I appreciate Councilman Bullock's attention to this matter. Whenever I think about the environment, I think of Councilman Bullock because he is a steward of clean earth and longevity for our planet, so I do appreciate that. And I also appreciate you giving attention to the hard work the Tree Task Force has done to make a clear presentation to those of us on council so we could really appreciate how important the tree canopy is to our city and the value it brings to our property values as well. So thank you for bringing this forward, and I appreciate the Tree Task Force for their continued energy in this fashion. And I appreciate also the administration's attention to this. So thank you.
Thank you, Councilwoman Marks. And actually, I'm glad you interrupted me because that does bring to my attention the fact that we did have someone signed up to speak on this docket item, which was lost in the paperwork associated with the other docket item, Marianne Quaisbarth.
Good evening, Mr. President, council members, and the public. I am Marianne Quaisbarth UC. I'm a former member of the Tree Task Force and currently a Keep Lakewood Beautiful board member and chair of the Keep Lakewood Beautiful Tree Committee.
What's your address?
1057 Abbey Shepherd. Thank you. I, along with former Tree Task Force members David Sangre, John Palmer, Bob Rensel, fully endorse this thorough resolution Councilman Bullock has put forth. This document represents a culmination of the meticulous 2 years of work the members of the Tree Task Force performed in 2013 and 14. A detailed report of this work was presented to City Council and the public in April of 2014. The official disbanding of the Tree Task Force occurred in December 2014. Most of the former Tree Task Force members continue to their tree advocacy goal and are currently members of the Keep Lakewood Beautiful Tree Committee. The Tree Task Force created a mission statement that we work toward. It was to study and advise municipal officials and the public and recommend action on issues involving public and private trees in the city by generating a forward, multifaceted, sustainable plan to preserve, manage, and maintain and perpetuate a healthy, growing, and mature urban forest. So what are these reasons for maintaining and increasing a tree canopy? Maintaining an urban forest differs greatly from a natural forest where nature sows every seed and trees thrive and fall naturally without human intervention. In stark contrast, in a high population density city such as Lakewood, every tree planted requires human intervention, from the master plan of planting the right tree in the right place to the knowledgeable certified arborist professionals maintaining the tree throughout its lifespan, including planting, regular watering, annual pruning, and the time when it must be removed for safety reasons before it would fall. There are many beneficial reasons to maintain and increase our urban canopy in both public and private lawns. Besides the aesthetic beauty trees offer in all seasons, from the winter white you see today, the summer green, the fall color, trees also give many quantifiable benefits in an urban environment and need to be considered as infrastructure. The shade trees provide not only benefits people, but also the buildings by reducing cooling costs by nearly 30%. Tree shade has been proven to reduce temperatures on pavement by reducing fatigue, cracking, rutting, shoving, and other distress, saving 60% on repair costs. Trees reduce crime rates, domestic violence, cruising speeds, and noise pollution. Trees increase rental rates, property values, and prices consumers are willing to pay. A single tree can generate oxygen to support 2 people and remove 10 pounds of air pollution per year. 100 trees remove 53 tons of carbon dioxide or 430 pounds of other air pollutants from the air and the environment each year. An urban forest can reduce the annual stormwater runoff by 2 to 7%. A mature tree can store up to 50 to 100 gallons of water during large storms. A 10% increase in tree size and canopy can reduce 5% water runoff. Scale this up and the city trees could intercept significant amounts of pollution and water annually. It follows that trees benefit human health as it lowers the incidence of asthma, depression, and anxiety disorders. They help patients heal faster and people stay healthier and increase human longevity. These are all reasons the city of Lakewood and its residents can benefit from trees, which contribute to creating a more stable, economic, and healthful environment. The Tree Task Force recommended 19 goals to City Council in the past year in our report, and now these goals need to be translated into a legal document such as the resolution before you to have a reasonable and lasting value to the city. In closing, I leave you with this quote to consider. American forests tell the history and the likely future of human habitation, from National Geographic. In other words, whether conscious or unconscious, people like to be where the trees are. It is of great value and meaning to keep the word wood alive and growing in Lakewood. Since the lifespan of a mature large tree can be up to 50 to 100 years, it takes continual advanced strategic professional planning to maintain an urban canopy. Considering the lifespan of a large tree, what we do now will affect not only the livability but the economic stability of our city in the next half century or more. I thank you for your time and consideration and leave this important decision in your hands, our elected officials and city council members. Thank you.
Thanks. So with that, I believe I had started to make a motion to receive and file and refer to Public Works.
Second.
We have a motion and a second. Is there any additional discussion on that motion? Hearing none, all those in favor say aye. Aye. All those opposed, that motion passes.
Item 23, Resolution 885216, a resolution to endorse the principles for tree care and urban forestry management goals recommended by the Lakewood Tree Task Force.
Move to refer to Public Works.
Second.
Motion's been made and seconded. Any discussion on that? Hearing none, all those in favor say aye. Aye. All those opposed, that motion passes.
Item 24, communication from Councilmember O'Malley regarding appointment to Lakewood Animal Safety and Welfare Advisory Board.
Move to receive and file this communication.
Second.
Motion's been made and seconded. All those in favor say aye. Aye. All those opposed, that motion passes.
Item 25, communication from Councilmember Nowlan regarding allowing cyclists to ride in the Clifton Boulevard bus lane.
Councilmember Nowlan.
Thank you, Mr. Chair. Dear members of council, attached please find an ordinance which proposes to amend Lakewood codified ordinances to allow cyclists to ride in the Clifton Boulevard bus lane. This matter was first brought to the committee's attention by a November 2nd, 2015 docket communication from Law Director Butler, which we discussed earlier tonight. Please refer this ordinance to Public Works for further discussion.
Thank you. Thank you. Second, we have a motion and a second to receive and file that communication from Councilmember Nowlan. Is there any discussion on that motion? Hearing none, all those in favor say aye. Aye. All those opposed, that motion passes.
Item 26, Ordinance 1716, and ordinance amending Section 33108, driving in marked lanes or continuous lines of traffic of the codified ordinances, and making further provision in order to permit bicyclists to operate bicycles in bus lanes during restricted hours.
Move to refer to Public Works.
Second.
Motion's been made and seconded. Discussion on that motion. Hearing none. All those in favor say aye. Aye. All those opposed, and that motion passes.
Item 27, communication from Mayor Summers regarding partnership with Lakewood Board of Education for fiber optic network.
Mayor Summers.
Thank you, Mr. Chairman, members of council, members of the public. The attached resolution is proposed to begin discussions with City Council regarding our partnership with the Lakewood Board of Education and our shared use of the new public sector fiber optic network currently being installed. It is expected that this partnership between the city and the Lakewood Board of Education will be formalized into an agreement. Key elements of the expected agreement will include the cost of the installation of the last lengths of fiber to connect from the main trunks to each of the schools, the disposition of long-standing fee paid by the city to the Board of Education for use of television broadcasting services, and finally, the shared cost of maintenance of the new network. The agreement is currently being drafted to be reviewed by the Lakewood Board of Education. A final and mutually agreed-upon agreement will likely not be available until mid-March 2016. Please refer this proposed resolution to the appropriate City Council committee for further consideration and discussion. Respectfully submitted.
Thank you. Move to receive and file that communication.
Second.
Motion's been made and seconded. Any discussion?
Mr. Chair.
Councilman Bullock.
Thanks, Mr. Chair, or Mr. President. Mayor, could we get a brief update on the time frame for the installation of the fiber optic network, which is, I know, well, it's the project behind tonight's proposal. Thanks.
Sure. The citizens and council may notice big spools of cable in and around primarily our commercial corridors, but also at other points in Lakewood. Those are fiber optic cables. They're being strung as we speak. Actually, the warm winter gave us a leg up, allowed these folks to work throughout January and February in a manner that normally you couldn't do as well. So it's probable that the cable will be finished in its installation form probably by the end of March, at which point a significant amount of work will begin on the network gear. This is actually what they call dark fiber, which means we are going to light this fiber with our own networking gear and control it. So it's a public network controlled exclusively by public agencies in Lakewood. And that would include the Board of Education, the library, and the City of Lakewood, potentially Lakewood Catholic Academy and St. Ed's should they choose to participate, which at this point they are preparing for the eventuality that they would, but their current contracts prevent them from engaging in the near term. The point is this dark fiber will be lit by us, controlled by us. It will be very private in terms of its data integrity. We'll have portions of it that will be connected to the World Wide Web at blinding speeds, a factor of 100 times faster than we're currently experiencing here in City Hall. And that's an important element for us because currently several applications, including our building department, our fire department, and potentially many other enterprise applications will be hosted outside of our servers. We currently use cloud-based services for some significant portions of our ability to manage and access data. This 100 times speed will facilitate our capacity to do our work and create other opportunities as well. And for the schools, being able to have that kind of blending speed is, you can imagine a student working at those speeds would be an exciting element. So the point is, I think that we can expect by June that we will have a finished lighted network, certainly on the city side. The schools are targeting more likely a July and August installation, and that accommodates their new school buildings, the 3 that they will go into this fall.
Thank you. And actually, that serendipitously brings up the point that late last week I was in contact with Superintendent Patterson of the Lakewood City School District regarding the possibility of City Council having a joint meeting with the Board of Education at some point in the relatively near future this year to address issues facing both entities. And we have, as council members will recall, done a joint meeting in the past to address such issues, and I would look forward to possibly addressing this and other issues with the Board of Education in the future. On that, I believe we have a motion to receive and file the communication from Mayor Summers and a second. Is there any further discussion? Hearing none, all those in favor say aye. Aye. All those opposed, that motion passes.
Item 28, Resolution 885316, a resolution to enter into an agreement with the Board of Education of the Lakewood City School District to authorize the connection of the public school buildings to the fiber optic network that is currently under construction within the city of Lakewood.
Move to refer to Committee of the Whole.
Second.
Motion's been made and seconded. Any discussion on that motion? Hearing none, all those in favor say aye. Aye. All those opposed, that motion passes.
Item 29, communication from Mayor Summers regarding boards and commissions appointments.
Mayor Summers.
Thank you, Mr. Chairman, members of council, members of citizens. I'm very pleased to announce 7 reappointments to our important boards and commissions, and I'll read those. In addition, 5 new appointments. The reappointments include Patrick Corrigan to the Board of Nuisance Appeals Abatement Board, Matt Sadler to the Board of Nuisance Abatement Appeals Board, Chuck Shaughnessy to the Board of Nuisance Abatement Appeals Board, Melissa Mixner to the Audit Committee, Bernadette Elston to the Community Relations Advisory Board, Bo Rogg to the Animal Safety and Welfare Advisory Board, and Joe Dix to the Community Reinvestment Area Housing Council. New appointments include Brian Bardwell to the City Records Commission, Harry Lader to the Community Relations Advisory Commission, Steve Lamontia to the Citizens Advisory Committee, Steve Jules to the Heritage Advisory Board, and Robert Cheffins to the Loan Approval Board. As always, we're grateful for these citizens and their willingness to step forward and serve our community in these important assignments.
Thank you very much, Mayor. I would move to receive and file that communication.
Second.
Motion's been made and seconded. Any discussion? Hearing none, all those in favor say aye. Aye. All those opposed, that motion passes.
Item 30, communication from Police Chief Malley regarding crisis intervention teams.
Chief.
Thank you, Mr. President. Basically, we have a letter to council about the Lakewood Police Department being notified that we've received a $1,000 grant from NAMI, the Ohio Attorney General's Office, and the Office of Criminal Justice Services to provide training for some of our officers in a crisis intervention team model. And we're doing this in conjunction with all our West Shore Enforcement Bureau partners and the Metro Parks Rangers. And this would be the first crisis intervention team on the west side of Cleveland.
Thank you. That's very exciting. Move to receive and file that communication.
Second.
Motion's been made and seconded. Any discussion on that communication? Hearing none. All those in favor say aye. Aye. All those opposed, that motion passes.
Item 31, communication from Law Director Butler regarding 2015-16, maybe, fourth quarter codification ordinance.
Thank you. Law Director Butler.
Thank you, Mr. Chair. Would you mind if I spoke from the lectern? I'm kidding.
Sure.
That's a joke. This communication merely precedes an ordinance that sends the codified ordinances from the fourth quarter of 2015 to Walter Drain for book and online codification. Thank you.
Thank you. Council members might recall, as well as potentially some members of the audience will recall, each quarter council is called upon to pass an ordinance instructing our online codifier publisher to publish the updated version of the ordinances. Historically, this has been at times referred to Rules and Ordinances Committee, or more recently, without objection from council members, left on the general docket as a largely ministerial measure. Without objection, that would be my preference for this piece of legislation this evening. But first, I would move to receive and file the communication from Law Director Butler.
Second.
Motion's been made and seconded. Any discussion on that motion? Hearing none, all those in favor say aye. Aye. All those opposed, that motion passes.
Item 32, ordinance 1816, an ordinance to approve the editing and inclusion of certain ordinances and resolutions as parts of the various component codes of the codified ordinances and to provide for the publication of such new matter.
Move to place on first reading.
Second.
Motion's been made and seconded. Any discussion on that motion? Hearing none, all those in favor say aye. Aye. All those opposed, that motion passes.
Item 33, communication from Finance Director Pay regarding 2016 capital lease authorization.
Director Pay.
Thank you. Dear members of council, attached is an ordinance to enter into agreement with a yet-to-be-named financial institution. and that financial institution is U.S. Bancorp. We awarded that today for the 2016 capital leasing program to finance the following that's listed in the correspondence in an amount not to exceed $1.617 million. Please refer to the Finance Committee for further discussion.
Thank you. Move to receive and file that communication.
Second?
Motion's been made and seconded. Any discussion on that motion to receive and file? Hearing none, all those in favor say aye. Aye. All those opposed? That motion is passed.
Item 34, ordinance 1916, an ordinance to enter into equipment leases and forms approved by the Director of Law on behalf of the City of Lakewood.
Move to place on first reading and refer to Finance.
Second.
Motion's been made and seconded. Any discussion on that motion? Hearing none, all those in favor say aye. Aye. All those opposed? That motion passes.
Item 35, communication from Finance Director Pay regarding 2016 first quarter transfers and advances.
Director Pay.
Thank you. Dear members of council, this is the first quarter transfer ordinance, which reflects 25% of the total anticipated transfers between funds that was included in the 2016 appropriations. Also, it includes $331,000 that was advanced from the general fund at the end of the year in 2015 to 4 separate funds, and those 4 separate funds are paying back the general fund. So please refer to the Finance Committee for further discussion. Thank you.
Thank you. Move to receive and file that communication.
Second?
Motion's been made and seconded. Any discussion? All those in favor say aye. Aye. All those opposed? That motion passes.
Item 36, ordinance 2016, an ordinance authorizing the transfer in advance of certain funds.
Move to place on first reading and refer to Finance.
Second.
Motion's been made and seconded. Any discussion on that motion? Hearing none, all those in favor say aye. Aye. All those opposed? That motion passes.
Item 37, liquor permit application to Barocco Grill, 12906 Madison Avenue.
Thank you. I would refer this matter for introduction to Law Director Butler or Chief Malley for synopsis.
Thank you, Mr. Chair. The application that's before you is a modification of the application that you've approved in recent weeks with respect to a new liquor permit at Barocco Grill. The modification is a result of the fact that the owners have added an additional owner to their owner mix who wound up having no criminal history at all, and so therefore presented no reason to object to our Division of Police or to the Law Department. So we pass that recommendation on to you.
Thank you. I do appreciate that, and by way of history, again, as Law Director Butler mentioned, this was a liquor permit application that was recently approved by Council and has since added a new owner. This particular establishment lies in Councilman O'Malley's ward. Typically, we would defer to him for whether or not there's a statutory objection. In his absence this evening, I defer to his at-large colleagues to express any statutory objection that they might have.
I have no objection.
All right, hearing no objection, I would move that Council recommends approval of the application without objection.
Second.
Motion's been made and seconded. Any discussion on that? Hearing none, all those in favor say aye. Aye. All those opposed? That motion passes. And that brings us to the end of our agenda for this evening. That's okay. We do have a couple individuals signed up for public comment, the first of which is Judy Gillespie.
Do I have to give my address again?
Did you move?
What's that?
Did you move?
No, I didn't. Thank you very much. I appreciate this file too. Okay, this is just a little bit of housekeeping, and I can't help but be a mother, and so I wanted to quote my source was from the Plain Dealer on 12/17/14, and it spoke about the Lakewood City Council expects to vote on 12/15/14 approving the raises for the council people. That they were currently at $7,000 per year, and that it was going to be raised to $13,000. For those mathematicians that aren't behind me, that's an 86% increase, which isn't too darn bad, I'll tell you. And that there is a cap of 16,000, which it could go up higher because of some people desiring benefits. The Civil Service Commission, stated that to attract the best candidates, the city needs to provide a total compensation package commensurate with the scope of responsibilities and time management required. So I'm understanding that even though it's not a lot of money for all the work that you have to do, you are paid by these people sitting behind me. And that sort of makes us a real important part of your job. And I am respectfully recommending that council and the floor members consider leaving your electronic devices, including magazines for the lady over here on the end, and computers, with maybe the legislator liaison, Maureen, because I find it very distracting when I get to sit there and watch everybody looking at their little computers while everybody's standing up here talking about things that we really truly believe in and that we want to communicate to you with. But when you can sit down and look at your phone without us noticing it, or I can see the reflection on your faces because you got a tablet there. One of the things I know that with monthly meetings, twice a month, that you guys have to be here to do this. And I know it isn't helpful and boring to some people. But when I looked at that magazine today, and trust me, there's been cell phone jokes or whatever that makes them laugh and they're having a good time. But I'm just thinking that as professionals, I just would really desire to see a better conduct from our side to what you're doing. I also would like to, since I signed up to do this, I'd like to finish my last page, that I was going to point out that when the city of Avon was approached by the Cleveland Clinic to build their proposed hospital on the Dick Jacobs donated land, Cleveland Clinic was told by the city of Avon that the city of Avon, did not agree that the city needed a third hospital to serve their residents. Therefore, the city of Avon would not pay for the Nagel Road traffic exchange, and therefore the Cleveland Clinic had to pick up that bill. Isn't that awesome that the city of Avon stood up for the people that live there to say, we're not going to pay for Cleveland Clinic's fancy road to service their building where they're going to make all their profit. So I think it's kind of nice that there are some cities that do stand up for the people that they represent. That didn't stop the Cleveland Clinic, though. They just pushed to get more money from you guys up there while they were closing Lakewood Hospital, from which in their plans started back in 1997. As the last sentence states in my definition of accountability, taking accountability means admitting you made a mistake. The handwriting is clearly on the wall. You only have to be willing to admit your mistake and be willing to change it. Thank you.
Thank you. I would like to respond just briefly to the comments about electronic devices, because I do think it's important. I absolutely hear your request for respectful conduct. I think that that's entirely appropriate and absolutely an expectation that individuals and citizens addressing council should have. My only note would be that it is my experience that the individuals you see engaged on electronic devices are doing so in the course and scope of the meeting. As you know, many of us have emails that we're consulting because we've received communications from constituents on a certain subject that is then referenced in the meeting, or frankly, for ease of looking at the docket. It's also something that's come up a number of times. I know recently people have asked in the course of a meeting, is such and such on the website, or can such and such be made publicly available? And so for those reasons, I find it extraordinarily helpful to have some form of an electronic device with me. I think going forward, you'll usually see me up here with a laptop. I forgot it tonight, and so I've been on my phone to some extent looking at the various documents that I've had to look at tonight. But I just wanted to make that comment because I do feel that it's important, incredibly important, that people feel respected when they're addressing council, And this would be one of the rare instances where I would speak for my colleagues in saying that it would be very unfortunate and disturbing for us to know that in looking at the docket or something, we might have caused any disrespect. So, Mayor, I believe you also wanted to follow up.
Just to correct the record, the city of Avon actually paid half of the Dago Road exchange. They paid $10 million. So, and the clinic paid the other half.
The inspector I talked to didn't tell me that.
Well, the mayor of Avon told me that.
Did you have
Okay.
it in writing, or did he just tell you?
Thank you. We'll have to, you'll have to catch up offline on that if you want to go back and forth some more. Our next speaker is Mr. Gerald Phillips.
Gerald Phillips, 461 Windward Way, Avon Lake, Ohio. I'd like to continue with the comments that I could present before. I'd like to comment on Law Director Butler's letter that he presented on last Thursday regarding the Middleton-Ferguson case. That case is clearly distinguishable. It wouldn't be precedent in a case where there's a perpetrated fraud by the clinic upon counsel to make the bad deal that you did, the master agreement, because there'd be a remedy for rescission of that contract. Also, it would be authority in a situation where the contract is invalid because the procedures of counsel weren't followed correctly. That contract would be void ab initio, especially when you didn't follow the appropriate bidding procedures. I know there's a difference of opinion. I researched it. I don't think you follow the law. Third, the Ferguson case, Middleton case, dealt with a situation where it was a road improvement, not a hospital health care issue. It was an initiative petition. It wasn't a referendum. In that particular case, there was no remedy for damages for breach of contract in the Middleton case. In fact, the court decision says this initiative ordinance went beyond a mere breach of contract because its passage precluded any remedy in damages. Instead, it had been given effect that the ordinance would have brought about an impairment of the obligations of the contract between the city and NODOT. So that eliminated damages and remedies, which is totally distinguishable from the present situation, so it wouldn't be applicable. Also, Lakewood is a home rule charter city. You have a charter provision, Article 25, Section 11. And pursuant to that provision, it talks about referendum, and the clinic really didn't acquire any vested rights. They acquired rights that were subject to divestiture pursuant to that section. And also, the clinic will be deemed to have notice, actual and constructive notice of that provision. So that clearly distinguishes it from the Ferguson-Middletown case. I know the Middleton-Ferguson case was presented, to give authority, to the, strategy of delay in order to invalidate any vote by the people. I'd like to comment on 4915. That ordinance had an emergency clause. I believe that emergency clause is invalid. It's perfunctory. It's just a recital. There was no emergency. It's really ineffective. Its purpose and design was to prevent the right of referendum and it being delayed. That was the intention. It was also designed to make ineffective any election by a referendum. It was also to assist in the Middleton case, to accelerate performance under the master agreement to try to invalidate any election. And I'm sure the Middleton-Ferguson case was well known prior to December 21st, 2015. It was part of the strategy. And if you look at it, on December 21st, 2015, this council passed by emergency the agreement for the master agreement. The next day in court, on the 22nd, the legal team of the council, the law director, Thompson Hines, and the clinic lawyers file a motion to dismiss for lack of jurisdiction based on that master agreement, alleging that there was a mutual release of claims. So don't tell me that there wasn't a foregone plan to enact that in an emergency, and the next day go to court to get the lawsuit dismissed. I mean, you know, let's not kid anybody, okay? You know, I'm a lawyer, I know the legal chess game. That was your strategy, and that was your legal team's strategy. I agree with Mr. Butler when he made a comment about that you have a mandatory duty to put 1716 on the ballot, that you can't question the legality of that. You do have some wiggle room in order to delay it, which I'm sure you've been advised, and that's why you're delaying it. You know, the only question is, did you abuse your discretion? This is a similar tactic that was used in the Lakewood West End project that I did, and the city used the delay tactics to prevent a vote in the November election because that wasn't in their best interest, and they wanted to win the game in the legal chess game. There's been issues
All
about
right,
sunshine.
we'll have to move on to our next
I
speaker.
hope somebody gave you-
Our next speaker is Jay Carson.
Well, you know, the transparency issue, you know, there's been issues about sunshine law violations.
Excuse me, sir.
And,
Excuse me, sir. I called the next speaker. The next speaker is Jay Carson. Thank you.
yeah, you know what? You don't want to hear the truth, and you don't want to hear nothing anyway. So, you know, you talked about bad deals. You know, when everybody gets done, I'll give you 6 points why that deal's bad if you want to hear it. If you don't want to call me back, then it's purely what Kevin Young said about
Sir,
trust.
please be seated.
You don't want to hear the truth because the truth hurts, and you don't want the people to know. This is nothing but a sham game. You guys are an insult to your constituents.
You're embarrassing yourself, sir.
No, I'm not. No, I'm not. Okay, you don't want to hear the truth.
Sir, be seated.
Because I heard the August 24th, 2015
Be seated or you'll be removed.
meeting where Mr. Bullock, you know, raised points. And you know what? You guys are just as a dog and pony show.
Mr. Carson.
Thank you. Jay Carson, 13938 Lake Avenue. President O'Leary, members of council. Last week, the petition committee had its opportunity to argue the merits of its case for appeal. The committee declined to address the merits. And instead, we heard about Bob and Judy and Brendan and Chelsea and how excited they were to sign the petition. Well, I've read the literature that was circulated by the petition committee. I spoke to one of their petition circulators back in January, and I listened to what they had to say last week. And I fear that Bob and Judy and Brendan and Chelsea and many other signers have been sorely misled. The claims that have been made to get people to sign the petition, and indeed the claims that Save Lakewood Hospital Group has been making for the last 13 months, simply aren't true. In the interest of time, I'll limit my remarks to 3 gargantuan myths that have animated the petition drive. There are more, but these are the big 3. The first myth, and this is something the council has already alluded to and spoken to tonight, is that the process was somehow improper. Again, the petitioners took this claim to court. They had the opportunity to present evidence, to cross-examine witnesses. They produced nothing. The court dismissed the case holding there was no evidence presented that any deliberations occurred or actions taken were in violation of Ohio's open meeting laws. In fact, the judge went out of his way to note from the bench that he was troubled that so much of the evidence presented during the hearing was based on rumor and hearsay. And despite that, throughout tonight and last week, they continued to beat the drum talking about secret meetings, backroom deals. Mr. Essie, who's the group's designated spokesman, continues to write his conspiratorial musings about a shadow government and a hidden agenda. But these claims persist, despite a year of public hearings, hundreds of opportunities to be heard and produce evidence, and the court's decision shows just how divorced from reality the Save Lakewood Hospital Group has become. May have begun as earnest citizens who might have had a meaningful contribution to debate, but it has quickly fallen victim to its members' paranoid fantasies. While Lakewood residents might still appreciate their passion, as the last election showed, they are not willing to abandon the facts and join Save Lakewood Hospital on its grassy knoll. The second myth is that there are other offers from other entities to continue to operate the hospital as an inpatient facility. Again, the literature that was circulated in support of the petition claims that the city turned its back on 3 viable offers. Again, it's just not true. Metro Health said publicly and unequivocally it wasn't interested in taking over Lakewood Hospital. But they've still peddled that myth. Then we heard about surgical development partners. But SDP never offered to run an inpatient hospital in Lakewood. They offered a medical building, they offered to buy a medical building in Westlake. This isn't just my opinion. This is plain to read. It's printed in black and white on SDP's correspondence with the city. Last week, the petition committee alluded to even more potential suitors. A secret group of doctors that cannot appear in public for fear of retribution and feels comfortable only dealing through Mr. Essie. There's also another group that apparently wants to work through Mr. Monahan rather than contact anyone at City Hall or LHA. I just want to ask, does anyone believe that's how healthcare companies make multi-million-dollar proposals to operate a hospital? And if so, is that the type of company we want as a partner? There were other suitors that were interested in running an inpatient hospital in Lakewood. Why didn't we hear from them? Throughout last year's meetings, those doors have always been open, this podium's always been here, but none of these white knights have shown up. It's because they don't exist. And the last myth, and the most pernicious myth, is that Lakewood is losing its ER, and that people's lives and health will be in danger. You've heard and will continue to hear that lives are at stake, that the ER is an ER in name only. In fact, a petition circulator told me there will be only 1 doctor on call, and that the ER will only be able to treat 4 people at a time. Just as there are penalties in every football game, any robust debate is going to yield some rhetorical excesses. But this type of cynical tactic of trying to scare the sick, the elderly, and the vulnerable residents of our city with this type of nonsense is just wrong. It's dishonest and it's shameful.
Mr. Carson?
Yes.
I'm sorry, you're up against the 5 minutes.
Thank you for your time.
Thanks. Our next speaker is Ed Graham.
Edward Graham, 1286 Chase Avenue. I take this opportunity to make a public records request. I request the Thompson-Hine Law Firm fee agreements, any fee agreement between Thompson-Hine and the city, and any and all fee bills submitted by Thompson-Hine. And I would also ask for the minutes of the Records Commission for the years 2013 through 2016. The restriction provision in this master agreement, I mentioned this last week, I'd mention it again. I still have not heard any member of the city council or any member of the administration point out some benefit that the citizens of the city of Lakewood have by disabling the very worthwhile facility they have known as Lakewood Hospital. Collaterally, it just came to mind. I question why the Cleveland Clinic is putting up signs on our property calling it the Cleveland Clinic when it is not a Cleveland Clinic facility. I would suggest that our officials see that such signs are removed. Even if you go by the agreement, the master agreement, that property has not been transferred and should not be transferred according to that agreement to the Cleveland Clinic. Therefore, they have no business putting their sign on our property, and I would request our administration to see that they are removed. As was previously mentioned by one of the other speakers, the ordinance passed as an emergency ordinance is totally fallacious. There was, I believe I mentioned this at the special council meeting, there was no emergency for the city of Lakewood. Maybe the clinic felt it had an emergency, but the city of Lakewood had no emergency. They had a long-term lease, another 10 years to go on its lease with the clinic. The clinic was under the obligation to see that the city hospital made money, to see that it was turned over at the end of those 10 years or so to the city of Lakewood as a going concern. It was responsible for any losses. So there was no restriction, and I will repeat that again and again. Show me or any of the other citizens of our city how the city of Lakewood derived the benefit of crippling our very valuable hospital with a restriction. And Council President mentioned the idea of individuals and citizens addressing the council and with propriety, I suppose you might say. I think the same thing should apply to the members of the city council, not to be taking cheap shots at citizens once they have finished addressing council and then say, well, your 5 minutes are up. You can't respond to some cheap shot addressed at citizens after they have addressed council. So I would think that should be something that should be given serious thought by the city council members. And the communications, one other request for public records. I want a copy of all communications from Thompson Hine to the city of Lakewood and from the city of Lakewood to Thompson Hine. Thank you.
Thank you. Our next speaker is Tara Pepper. Oh, okay. Then the next speaker is Kevin Young.
Kevin Young, 1598 Elber Avenue. Thank you for this opportunity to speak again. Ed Graham was telling me about the great days when he was council president and there was no 5-minute limit. Maybe something to consider. It is pretty tough to get up here and speak. Maybe it might be a good idea to get one of those big clocks. I swim laps at the Lakewood pool, and they have a big clock, so that everybody could see the time passing along, and we could all be sure. I know it would help me if I could actually see the time pass away, and I would know, when to wrap things up. I think it would help us all. So.
I watch it.
Yeah, but that doesn't have a timer on it, and that's not right where you can see it. Let's put it right up there, President Sam, right under where you're sitting there. Just a suggestion. I'll say it again. I actually like a lot of you folks up there on the dais. I think this has really been hard on all of us. Let's get this vote on the ballot just as soon as possible. This isn't over yet, and it's not going to be over until that gets to the ballot. Thank you.
Thanks. Our next speaker is Brian Essie.
Thank you. I haven't moved either. Mr. Carson came before this body and claimed to be threatened by a post that I wrote, claimed his children were in jeopardy, and then he ran out of his place and wrote a post on Facebook saying he left the lights on for me. I think that's a matter of public record. I put it in the record. So he's been here representing a number of parties, North Coast Health Ministry. He served a pleading on behalf of Build Lakewood. Build Lakewood did not represent itself to be a PAC. In that pleading he filed, which was dismissed by the court, he represented that Build Lakewood was a PAC. But let's talk about facts. I don't want to talk about law and personal attacks. No bidding, Mr. O'Leary mentioned that no bidding was necessary because the deal got better. And it got a better result. I think objectively this deal got worse. The present value of the payments under the master agreement were less than the value of the payments under the master agreement. So I disagree that. And Mr. Bullock mentioned we shouldn't tip our hand in the negotiations, and this was the reason to be behind closed doors on various things. And I don't dispute that behind closed doors was necessary on certain things. And you've never heard me claim open and honest, you've heard me claim that. You've never heard me claim before this body about executive session. I've commented very little about it. But the not tip your hand, really, in my 32 years of being a lawyer in negotiations, when we have a law director who, in the midst of an election, basically publishes his legal opinions in a question and answer, saying we have no rights against the clinic on the eve, practically, of being given authority to negotiate them. That is really not a good negotiating strategy. Factually, I don't think that's an opinion. That's just bad. Now, I have a records request. I would like the 2015 LHA profit and loss statements, financial statements, even though they're not in, or the fourth quarter, because I know those come to the city. So I'd like those to be delivered to me. Thank you. The other question was the release of the tortious interference. That came 2 days after Metro finally pulled out. So I commend the council. I never saw that in a public way that you worked to try to, get lack of a tortious interference claim. But the letter came after Boutros pulled out, and there was a lot of, he called it a maelstrom of activity. It just wasn't handled, in my opinion, professionally. We needed a professional in charge of the city's responsibility to bid. The process was improper, I guess, is what Mr. Carson argued here. That was one issue, one sunshine issue that was before the court. So it wasn't the whole case. As well, I think I like to argue logic, and it doesn't seem logical to me and proper for the body to say that if we assume what Mr. Butler said here tonight and the other night, Thursday, was correct, that this is going to result in a breach of contract by repealing this, or by the referendum, if I heard it right, referendum being passed. We all knew this referendum was coming. It's in your legal rights, apparently, to have structured it to defeat the referendum. But I don't think that was very wise. And it seems to be a contradiction in logic that the vote doesn't nullify the contract, and in law, yet the repeal would breach the contract. Just a little bit of logic that doesn't make a lot of sense to me. So I guess in the, about the SDP thing, we can go back and forth. About the ER, we can go back and forth. We talked about guarantees here. People asked me last week about guarantees. I think we have two gentlemen here tonight, Mr. Gable and Mr. Haber. I'm sorry. Both of those gentlemen admitted to me in April, at least pertaining to the LOI, as soon as we sign that deal, we have no control over the clinic. I don't believe, and this is an opinion, I don't believe that the master agreement really gives us much guarantee of service. It really just says as long as they have a family health center, we have an ER that is at least as good as what existed on the 21st. And I look forward to Chief Gelman's response to me online so we can really figure out whether there's anything, and I asked for public records, I guess, instead of putting it on Mr. Gilman. What is it, the standard that we're going to be judging the clinic's agreement by, as to what those services actually were on the 21st?
Mr. President, thank you. That'll do it for tonight. Okay, that brings us to the end of the signed up public comment for this evening. Any announcements from the administration? No, none. Announcements from council, Councilwoman Marks.
Yes, thank you. I just wanted to let everybody know, I believe on the HGTV network tomorrow night at 10 o'clock, there's going to be, Lakewood will be representative as a house buying opportunity. So I've heard that Lakewood shows up great, and I think we should all watch it and remember how great a community we really are. Thank you all. Have a good evening.
Thank you. I would move to adjourn. Motion's been made and seconded. Any discussion? Hearing none. All those in favor say aye. Aye. And we are adjourned. Thanks, everyone.